Hello everyone, this is part 3, and in this video we're gonna discuss the AIBE 10 previous year question paper from question number 66 to 100। इससे पहले दो पार्ट इसके मैंने बनाए हैं, तो 66 क्वेश्चन नंबर 65 तक उसमें है, उसके आगे जो है कंटिन्यू हम करेंगे। ठीक है। Question number 66. The parties which cannot be compelled to perform a specific performance of contract are provided in which is a section of specific relief? Wait, there is something issue. An issue has been arised. So we were on question number 66. The parties which cannot be compelled to perform a specific performance of contract are provided in which section of a specific relief act? Option is section 727, section 28, section 29, section 30. Its right option is option 66 का right option is option B, which is section 28. Question number 67. What is the special constitutional position? What is the special constitutional position of Jammu and Kashmir? Option A. It is above Indian Constitution. Option B. Indian laws are not applicable. Option C. It has its own constitution. Option D. It is not of the integral parts of यूनियन इन इंडियन यूनियन। तो ये क्वेश्चन अब वॉइड हो जाना चाहिए, क्योंकि अब जो है जम्मू एंड कश्मीर इंटरनल पार्ट ऑफ इंडिया, वैसे पहले भी था बट अभी भी है कॉन्स्टिट्यूशनली बेसिस पे अगर बात करें तो। 2019 में जो एक्ट आया था 67 का, इसमें राइट ऑप्शन दिया हुआ है इट हैज़ इट्स ओन कॉन्स्टिट्यूशन, बट वो अब अबॉलिश हो चुका है। ठीक है, तो ये क्वेश्चन जो है कैंसिल, इसको इसको कैंसिल कर सकते हैं। Question number 68. A person cannot be a next friend, a guardian of a person if option A he is a minor, option B he is an opposite party in the suit, option C he has not given consent in writing, option D all of the above. Its right option is option D all of the above. A person cannot be a next friend, a guardian of a person if he is a minor, if he is an opposite party in the suit, if he has not given consent in writing. Question number 69. In which section of the Hindu Succession Act 1956 the law of Mitakshara has been incorporated? Right option is option D, which is section 6. Question number 70. The chief elements necessary to constitute a crime are, the chief elements necessary to constitute a crime are option A human being, option B an evil intent, option C injury to another human being or society, option D all of the above. Its right option is option D all of the above. Question number 71. Dealer includes a person who is engaged. Question number 71. Includes a person who is engaged. Option A in building bodies for attachment to chassis, or option B in the repair of motor vehicles, or option C in the business of hypothecation, leasing or hire purchase of motor vehicle, option D all of the above. Its right option is option D all of the above. Question number 72. Under section 25 of the Land Acquisition Act, the amount of compensation awarded by the court, option A shall not be less than the amount awarded by the collector under section 2, option B shall not shall not be equal to the amount awarded by the collector under section 2. Option C shall not be more than the amount awarded by the collector under section 2. D. All of the above. Its right option is option A, shall not be less than the amount awarded by the collector under section 2. Question number 73. The undertaking contained in a promissory note to pay a certain sum of money is the undertaking contained in a promissory note to pay a certain sum of money is option A conditional, option B unconditional, option C may be conditional or unconditional depending upon the circumstances, option D all of the above. Its right option is option B unconditional. Question number 74. Recently, in which case the Kerala High Court held that a university grant commission criterion which allowed certain relaxation in marks to reserve categories as violation of Article 16 Clause 1 of the Constitution. Option A Nair Service Society versus UGC. Option B CBSE versus UGC. Option C UGC versus State of Kerala. Option D UGC versus Secretary of State. Its right option is option A. Nair Service Society versus UGC VPC number 5190 of 2016 W. Question number 75. In which of the following cases it was said that unless a right of appeal is clearly given by a statute, it does not exist? Question number 75. In which of the following cases it was said that unless a right of appeal is clearly given by a statute, it does not exist? Its right option is C, which is Zair Hussain Khan versus Khurshid Jain, 1906, ILR 28, all 545. Question number 76. Which of the following sections deals with the provisions relating to maximum period for which an under trial prisoner can be detained? Option is 436, option B 436A, 437A, 437. Its right option is option B 436A. Question number 77. To make the criminal harmless by supplying him those things which he lacks and to cure him of those drawbacks which made him to commit crime is known as option A expiatory or penance theory of punishment, option B deterrent theory or preventive theory of punishment, option C reformative or rehabilitative or corrective theory of punishment, option D retributive theory of punishment. Its right option is option C reformative or rehabilitative or corrective theory of punishment. Question number 78. Pakala Narayan Swamy versus Emperor is a leading case on right option is dying declaration, option B confession, option C accomplice, option D expert witness. Right option is option A dying declaration. Question number 79. Who are the partners in a bill of exchange? Option A drawer and drawee, option B pay, option C both A and B, option D none of the above. Its right option is option C both A and B. Question number 80. Income which income which accrue or arise outside India but are directly received into India are taxable in case of option A residents only, option B both ordinarily residents and non-resident, option C non-resident, option D all the excesses excesses. Its right option is option D all the excesses. Question number 81. a a surgeon, knowing that a particular operation is likely to cause the death of Z, who suffers under a painful complaint, but not intending to cause Z's death and intending in good faith Z's benefit, performs that operation on Z with Z's consent, he has committed no offense. It is contained in option A, section 88 of the IPC, option B, section 89 of the IPC, option C, section 90 of the IPC, option D, section 87 of the IPC. Its right option is option A, section 88 of the IPC. Question number 82. A Hindu's widow, if there are more than one, shall take option A one share each, option B one share for all the widows, option C one share each to the maximum of two shares if there are more than two widows, option D none of the above. Its right option is option B, which is one share for all the widows. Question number 83, Section 112 of Indian Evidence Act provides that a child would be treated as legitimate if after dissolution of marriage he or she has been born within option A 180 days, option B 270 days, option C 280 days, option D 300 days. Its right option is option C, which is 280 days. Section 112 of Indian Evidence Act provides that a child would be treated as legitimate if after dissolution of marriage he or she has been born within 280 days. 280 days means almost 9 point something month, है ना, almost 9 month. Question number 84. Which of the following sections enables the court to cancel the bond and bail bond? Which of the following sections enable the court to cancel the bond and bail bond? Option A 446A, option B 446, option C 448, option D 450. Its right option is option A, which is 446A. 446, section 446A enables the court to cancel the bond and bail bond. Question number 85. A reference can be made during the pendency. Option A. The subordinate court refers the case to the High Court for the letter's opinion on a question of law. Option B. The subordinate court refers the case to the High Court for the letter's opinion on a question of evidence. Option C. The subordinate court refers the case to the High Court for the letter's opinion on a question of fact. Option D. The subordinate court refers the case to the High Court for the letter's opinion on a question of court procedure. Its right option is option A. The subordinate court refers the case to the High Court for the letter's opinion on a question of law. Question number 86. The right of equality. The right of equality before the law under Article 14 is subject to the restriction of. Question number 86. The right of equality before the law under Article 14 is subject to the restriction of option A public order and morality, option B reasonable classification, option C reasonable restriction, option D reasonable situations. Its right option is option B, which is reasonable classification. So the right of equality before the law under Article 14 is subject to the restriction of reasonable classification. Question number 87. The distinction between section 229 to 299 and 300 was made clear by Melville Justice in option A. Reg versus Guruchand Gop, option B. Reg versus Govinda, option C. Reg versus Hayward, option D. Govind versus Reg. And its right option will be option B, which is Reg versus Govinda. The light has been gone here, so there is a electricity shortage. So of course I am not visible, but let's focus on the question. Question number 88. Any person aggrieved by an order made by the disciplinary committee of the Bar Council of India under section 36 or 37 of the Advocates Act may prefer an appeal to the any person aggrieved by an order made by the disciplinary committee of the Bar Council of India under section 36 or 37 of the Advocate Act may prefer an appeal to the. It's right option. We have option A High Court, option B Supreme Court, state government, central government. Its right option is option B Supreme Court. Question number 89. A perpetual injunction, which is a permanent injunction. So, a perpetual injunction can only be granted by the decree at the hearing and upon the option A. Demand of the party, option B. Discretion of the court, option C. Merit of the suit, option D. None of the above. Its right answer should be, I think, C, which is merit of the suit. Let's confirm it. 89 का C, ठीक है, merit of the suit. Question number 90. The provision relating to abolition of untouchability is given in option A Article 23, option B Article 24, option C to Article 20, Article 17, option D Article 15. Its right option is option C, which is Article 17. So the provision relating to abolition of untouchability, relating to abolition of untouchability is given in Article 17. 10 more questions left. Question number 91. Under section 115, in the exercise of its revisional jurisdiction, a high court can do which of the following things? Option A. To call for the record of any case which has been decided by any court subordinate to the high court. Option B. To vary or reverse any decree or order against which an appeal lies to the high court. Option C. Both A and B. Option D. None of the above. Its right option is option A, which is to call for the record of any case which has been decided by any court subordinate to the high court. So under section 115, in the exercise of its revisional jurisdiction, a high court can do a high court can do he can basically call for the record of any case which has been decided by any court subordinate to the high court. Question number 92. In joint trial, the evidentiary value of confession of a co-accused affecting himself and others has been discussed by the Supreme Court in option A, which is Kashmira Singh versus State of MP. Option B, State of UP versus Dearman Upadhyay. Option C, Ram Bharose versus the State of UP. Option D, Rameswar versus the State of Rajasthan. Its right option is option A, which is Kashmira Singh versus the State of MP. Question number 93. Maintenance application under section 18 clause 2, under section 18 subsection 2 of HAMA is filed in. Maintenance application under section 18 subsection 2 of HAMA is filed in option A matrimonial court, option B district court, option C high court, option D any of the above. Its right option is option B, which is district court. So maintenance application under section 18 subsection 2 of the HAMA is filed in district court, which makes sense. Question number 94. Which of the following belong to the category of direct tax? Option A, goods and services tax. Option B, excise duty and custom duty. Option C, income tax and gift tax. Option D, all of the above. Its right option is option C, which is income tax and gift tax. These are the direct tax. Question number 95. The theoretical powers to amend the constitution has been given to the member of parliament and state legislatures by article option A article 358, option B article 368, जिस जो कि इसका obvious answer है, which gonna be option B article 368. Option C article 378, option D no such powers, and इसका right answer है option B, which is article 368. Question number 96. Under section 114, a person can apply for review of judgment. Under section 114, a person can apply for review of judgment when option A is agreed by a decree or order from which an appeal is allowed, but no appeal is allowed. He is agreed by a decree from or order from which an appeal is allowed, but no appeal is allowed. Option B, he is agreed by a decree or order from which no appeal is allowed. Option C, he is agreed by a decision on a reference from a court of small causes. Option D, all of the above. So section 14 of CPC की बात हो रही है, and its right option is option D, which is all of the above. So under section 114, a person can apply for review of judgment when he is aggrieved by a decree or order from which an appeal is allowed, but no appeal is allowed. He is aggrieved by a decree or order from which no appeal is allowed. Option C, he is aggrieved by a decision on a reference from a court of small causes. Option D, all of the above. Right option is option D, which is all of the above. Question number 97. In which of the following cases the Supreme Court of India opined opined that bail is the surety and jail is an exception? Bail is the surety and jail is an exception. We have option जोगिंदर कुमार. This is important by the way. अभी हाल फिलहाल में भी ये आया हुआ था न्यूज़पेपर में. ऑप्शन ए जोगिंदर कुमार वर्सेस स्टेट ऑफ यूपी. ऑप्शन बी मोतीराम वर्सेस स्टेट ऑफ एमपी. ऑप्शन सी मनिका गांधी वर्सेस यूनियन ऑफ इंडिया. ऑप्शन डी स्टेट ऑफ वेस्ट बंगाल वर्सेस डी के बासु. Its right option is Motiram versus State of MP. Motiram versus State of MP. In this case, the Supreme Court of India opined that bail is the surety and jail is an exception. In which case, Motiram versus State of MP. Motiram versus State of MP. Question number 98. The provisions relating to compoundable offence is provided under section. The provisions relating to compoundable offence. The provisions relating to compoundable offence is provided under section. Option A 319, option B 320, option C 290 265D, option D 321. Its right option is option B, which is 320. Question number 99. Under which section of CPC option for settlement of dispute is provided outside the court? We have option A 81, 89.2, 89.1, 82. Its right option is option C, which is 89.1. Okay, so as per the section 89, subsection 1 of CPC, option for settlement of dispute is provided outside the court. Question number 100, which is last question, where a magistrate of the first class passes only a sentence of fine not exceeding rupees 100 against this order, where an appeal shall lie. Option A, in the court of Chief Judicial Magistrate. Option B, in the court of Chief Metropolitan Magistrate. Option C, both A and B. Option D, none of the above. Its right option is none of the above. ठीक है, तो कहीं इसका अपील नहीं जाएगा. So these were the 100 questions that we have just solved right now, and we solved AIBE 10th examination question paper, previous year question paper. I hope it will help you because it helped me while I was analyzing the question paper, and I assume that it gonna be help you too. So see you in next video. Till then, thank you.